Cyber thoughts are wrongdoings that can happen to basically anyone, anywhere, at any time. They are not peculiar to a specific class of people. Oh, this can never happen to me. I'm not even an internet person. No, because cyber thoughts have a variety of flavors. The cyber assailants, they're always coming up with new ideas. You need to be aware of your digital rights. No one is safe. Cyber thoughts are wrongdoings that happen online. Think of them as the digital version of someone hurting your reputation, invading your privacy, or causing you emotional distress. But instead of happening face to face, it happens through phones and computers, basically anything with an internet access. Hi, I'm Anthony Brown. I'm a legal practitioner in Lagos, Nigeria, and an advocate for digital justice. Unlike regular wrongs that happen in one place, cyber thoughts can happen anywhere at any time. The internet has no borders. That's what makes them tricky. Today, we have two agendas. First, in part one of today's analysis, we're asking what are the jurisdictional complexities in cyber thoughts? And in part two, which will be in another video because of length, we are diving into, in that one, we'll be diving into the second agenda, which would be what are the legal responses to cyber related offenses in jurisdictions like the United States, the European Union, and West Africa, Nigeria, where I reside. On jurisdictional complexities in cyber thoughts, we have access to websites as the jurisdictional basis. Back in 2002, a businessman named Joseph Gutnick from Victoria, Australia, found himself the subject of an online article published by Dow Jones, the American media giant. The article was uploaded in New Jersey, USA, but Gutnick felt the sting of its word right at home in Australia, so he sued. Though Jones tried to argue, hold on, the article was published in America, so the case should be heard in America. But the Australian High Court didn't buy that at all. They ruled that publication happens where the content is actually read and understood, not just where it's uploaded. In other words, if someone's reputation is damaged in Victoria, that's where the legal action belongs. This ruling changed the game in the sense that what it's saying is that if you hurt someone's reputation online, you can be sued where the damage is felt, not just where the content came from. That's called the effects based approach to jurisdiction. And it's a big deal in cyber law. It means victims don't have to chase publishers across the globe because that'll be very expensive. But publishers have to think twice about what laws apply in every country their content might reach. Other countries have taken notice. In Canada, the case of Bangura against Washington Post asked a similar question. If an article is online and can be read anywhere, does that mean you can sue anywhere in the world? The Canadian court said not quite. Just being accessible isn't enough. You need to establish that there's real harm that occurred in that location. And then we have the minimum contact doctrine. In the case of English sports betting against Tostigan in 2002, when an online defamation meets jurisdiction rules, a Jamaican company called English Sports Betting Incorporated, along with Pennsylvania residents named Dennis Atiye, claimed they were defamed in three online articles written by Mr. Christopher Sting Tostigan, a New York resident. These articles were published on two websites, one Canadian and one Australian, though operated from Virginia. And they accused Atiye of serious allegations, crime, murder, money laundering, using vulgar language, The plaintiff asked the courts in Pennsylvania to issue a default judgment against Tostigan. But before the court could do that, it had to answer a key question. Does the Pennsylvania courts even have the authority to hear this case? Under United States law, a court can only hear a case if the defendant has minimum contacts with the state, hence the name. That means the defendant must have intentionally interacted with the states. The lawsuits must be connected to those interactions, and it must be fair and reasonable to bring the defendant into the jurisdiction of the courts. The court found that Tostigan had no physical presence in Pennsylvania. His websites were aimed at a global audience, not specifically at Pennsylvania residents. The main harm to English sports betting would be felt in Jamaica, not Pennsylvania. There was no proof that Tostigan tried to benefit from Pennsylvania's laws or market. Even though the articles could be read in Pennsylvania and mention someone who resides there, that wasn't enough. The court said just being online and accessible in a state doesn't mean you can be sued there. The courts ruled that it did not have personal jurisdiction over Tostigan. A request for judgment was denied and the case was dismissed. Looking at the lessons from Dow Jones against Gutnick and English sports betting against Tostigan, we can begin to understand how Nigerian courts are shaping their own approach to online defamation and cyber torts. As more harmful content spreads through the internet, judges are being asked to decide not just what was said, but where the damage was truly felt. In Nigeria, Section 24 of the Cybercrime Act 2015 makes it a crime to defame someone online. But beyond criminal punishment, this law also recognizes that harm caused through the internet is real and often deeply personal. It quietly supports the idea that a court can hear a case if the harmful content was assessed in Nigeria and affected someone's reputation, even if the post or article came from another country or another continent. This leans towards the Gutnick model, where the focus is on the place of impact, not the place of origin. Nigerian courts seem to be moving away from the older location based rules of defamation and embracing a more modern view. The law is catching up with the digital world, and accessibility plus reputational harm are becoming key factors in deciding where justice should be served. We can also look at the case of Dele Farotumi against the Federal Republic of Nigeria, which I'll be covering in the um, judicial responses to cyber thoughts in West Africa, Nigeria. That would be in part two. Thanks for watching. Until next time, I'm Anthony Brown. Be safe.